The Constitutional Convention, also known as the Philadelphia Convention, the Federal Convention, or the Grand Convention at Philadelphia, took place from May 25 to September 17, 1787, in the old Pennsylvania State House, later known as Independence Hall because of the adoption of the Declaration of Independence there 11 years before, in Philadelphia, Pennsylvania. Although the convention was intended to revise the League of States and first system of government under the Articles of Confederation and Perpetual Union, which were first proposed in 1776, adopted by the Second Continental Congress in 1778 and only finally unanimously ratified by the original 13 states by 1781, the intention from the outset of many of its proponents, chief among them James Madison of Virginia and Alexander Hamilton of New York, was to create a new government rather than fix the existing one. The delegates elected George Washington of Virginia, former commanding general of the Continental Army in the late American Revolutionary War, 1775 to 1783, to preside over the convention. The result of the convention was the creation of the Constitution of the United States, placing the convention among the most significant events in the history of the United States and indeed of worldwide historical, political, and social influence. The most contentious disputes revolved around composition and election of the upper legislative house in the future bicameral Congress, to be known as the Senate, how proportional representation was to be defined, whether to include slaves or other property, whether to divide the executive power between 3 persons or invest the power into a single chief executive to be called the President, how to elect the President, how long his term was to be and whether he could run for re-election. What offenses should be impeachable, the nature of a fugitive slave clause, whether to allow the abolition of the slave trade, and whether judges should be chosen by the legislature or executive. Most of the time during the convention was spent on deciding these issues, while the powers of legislature, executive, and judiciary were not heavily disputed. Once the convention began, the delegates first agreed on the principles of the convention, then they agreed on Madison's proposed Virginia plan and began to modify it. A committee of detail, assembled during the July 4 recess, eventually produced a rough draft of the Constitution. Most of the rough draft remained in place, and can be found in the final version of the Constitution. After the final issues were resolved, the Committee on Style produced the final version, and it was voted on by the delegates, inscribed on parchment with engraving for printing and sent to the states and their legislatures. Historical context. Before the Constitution was drafted, the nearly 4 million inhabitants of the 13 newly independent states were governed under the Articles of Confederation and Perpetual Union, created by the Second Continental Congress. It soon became evident to nearly all that the chronically underfunded Confederation government, as originally organized, was inadequate for managing the various conflicts that arose among the states. As the Articles of Confederation could only be amended by unanimous vote of the states, any state had effective veto power over any proposed change. In addition, the Articles gave the weak federal government no taxing power, it was wholly dependent on the states for its money, and had no power to force delinquent states to pay. Once the immediate task of winning the American Revolutionary War of 1775 to 1783 had passed, the states began to look to their own interests, and disputes arose. These included a dispute between Maryland and Virginia over the Potomac River and opposition to Rhode Island's imposing taxes on all traffic passing through it on the post road. James Madison suggested that state governments should appoint commissioners to take into consideration the trade of the United States, to examine the relative situation and trade of said states, to consider how far a uniform system in their commercial regulations may be necessary to their common interests and permanent harmony. Another impetus for the convention was Shay's Rebellion of 1786 to 1787. A political conflict between Boston merchants and rural farmers over issues including tax debts had broken out into an open rebellion. This rebellion was led by a former Revolutionary War captain, Daniel Shays, a small farmer with tax debts, who had never received payment for his service in the Continental Army. The rebellion took months for Massachusetts to put down completely, and some desired a federal army that would be able to put down such insurrections. In September 1786, at the Annapolis Convention, delegates from 5 states called for a constitutional convention in order to discuss possible improvements to the Articles of Confederation. The subsequent Constitutional Convention took place in Philadelphia, convening in the old Pennsylvania State House, then becoming known as Independence Hall, on May 14, 1787. Rhode Island, fearing that the convention would work to its disadvantage, boycotted the convention and, when the Constitution was put to the states during the next year of controversial debates, initially refused to ratify it, waiting until May 1790 to become the 13th, a year after the new federal government commenced. The convention. Due to the difficulty of travel in the late 18th century, very few of the selected delegates were present on the designated day of May 14, 1787, and it was not until May 25 that a quorum of 7 states was secured. New Hampshire delegates would not join the convention until more than halfway through the proceedings, on July 23. James Madison arrived first, and soon most of the Virginia delegation arrived. While waiting for the other delegates, the Virginia delegation produced the Virginia Plan, which was designed and written by James Madison. On May 25, the delegations convened in the Pennsylvania State House. George Washington was unanimously elected president of the convention, and it was agreed that the discussions and votes would be kept secret until the conclusion of the meeting. Despite the sweltering summer heat, the windows of the meeting hall were nailed shut to keep the proceedings a secret from the public. Although William Jackson was elected as secretary, his records were brief and included very little detail. Madison's notes of debates in the Federal Convention of 1787, supplemented by the notes of Robert Yates, remain the most complete record of the convention. Throughout the debate, delegates constantly referred to precedents from history in support of their position. Most commonly, they referred to the history of England, in particular the Glorious Revolution, often simply called the Revolution, classical history, mainly the Roman Republic and the leagues of Greek city-states, and recent precedents from Holland and Germany. Outside the convention in Philadelphia, there was a national convening of the Society of the Cincinnati. Washington was said to be embarrassed. The 1,776 old Republican delegates like Elbridge Gerry, Ma, found anything military or hereditary anathema. The Presbyterian Synod of Philadelphia and New York Convention was meeting to redefine its confession, dropping the faith requirement for civil authority to prohibit false worship. Protestant Episcopalian Washington attended a Roman Catholic Mass and dinner. Revolution veteran Jonas Phillips, of the Mikveh Israel Synagogue, petitioned the convention to avoid a national oath including belief in both Old and New Testaments. Merchants of Providence, Rhode Island, petitioned for consideration, though their assembly had not sent a delegation. Manasseh Cutler came directly from the capital in New York and found himself a frequent dinner guest among the delegates. He carried grants of 5 million acres to parcel out among the Ohio Company and speculators, including some who were attending the convention. A Philadelphia guest of Robert Morris, Noah Webster would write a pamphlet immediately after the signing. Leading principles of the Federal Convention advocated adoption of the Constitution. It was published much earlier and more widely circulated than today's better-known Federalist Papers. James Madison's Blueprint. While waiting for the convention to formally begin, James Madison sketched out his initial draft, which became known as the Virginia Plan and reflected his views as a strong nationalist. By the time the rest of the Virginia delegation arrived, most of the Pennsylvania delegation had arrived as well. They agreed on Madison's plan, and formed what came to be the predominant coalition. By the time the convention started, the only blueprints that had been assembled were Madison's Virginia Plan, and Charles Pinckney's plan. As Pinckney didn't have a coalition behind his plan, Madison's plan was the starting point for deliberations. The convention agreed on several principles. Most importantly, they agreed that the convention should go beyond its mandate merely to amend the Articles of Confederation, and instead should produce a new constitution outright. While some delegates thought this illegal, The Articles of Confederation were closer to a treaty between sovereign states than they were to a national constitution, so the genuine legal problems were limited. Another principle they agreed on was that the new government would have all the powers of the Confederation Congress, plus additional powers over the states. Once agreeing on these principles, the convention voted on the Virginia Plan and signaled their approval for it. Once this was done, they began modifying it. Madison's plan operated on several assumptions that were not seriously challenged. During the deliberations, few raised serious objections to the planned bicameral Congress, nor the separate executive function, nor the separate judicial function. As English law had typically recognized government as having two separate functions, lawmaking embodied in the legislature, and law executing embodied in the king and his courts, the division of the legislature from the executive and judiciary was a natural and uncontested point. The division of the legislature into an upper and lower house wasn't questioned either, despite the obscure origins of the English House of Lords and its role as the representative of the hereditary nobility. 82 Americans had seldom known any but bicameral legislatures, both in Britain and in most state governments. The main exceptions to this were the dysfunctional Confederation Congress and the unicameral Pennsylvania Legislature, which was seen as quickly vacillating between partisan extremes after each election. Experience had convinced the delegates that an upper house was necessary to tame the passions of the lower classes against the interests of wealthy merchants and landowners. Since America had no native hereditary aristocracy, the character of this upper house was designed to protect the interests of this wealthy elite, the minority of the opulent, against the interests of the lower classes, who constituted the majority of the population. On Thursday, June 7, it was proposed that senators should be chosen directly by the state legislatures, instead of by popular vote, as this method was more likely to preserve the power of the upper classes. Convention delegate Elbridge Gerry of Massachusetts observed that the great mercantile interest and of stockholders is not provided for in any mode of election. They will however be better represented if the state legislatures choose the second branch. The proposal was carried unanimously. The delegates also agreed with Madison that the executive function had to be independent of the legislature. In their aversion to kingly power, American legislatures had created state governments where the executive was beholden to the legislature, and by the late 1780s this was widely seen as being a source of paralysis. The Confederation government was the ultimate example of this. Furthermore, in the English tradition, judges were seen as being agents of the king and his court, who represented him throughout his realm. Madison believed that in the American states, this direct link between state executives and judges was a source of corruption through patronage, and thought the link had to be severed between the two, thus creating the third branch of the judiciary, which had been without any direct precedent before this point. Madison, however, did not believe that the judiciary should be truly independent, but rather beholden to the legislature rather than the executive. At the convention, some sided with Madison that the legislature should choose judges, while others believed the president should choose judges. A compromise was eventually reached that the president should choose judges and the Senate confirm them. In a few areas, Madison's plan included provisions that had little support among the delegates. Few agreed with Madison that the legislature should be able to invalidate state laws, so the idea was dropped. While most thought there should be some mechanism to invalidate bad laws by Congress, few agreed with Madison that a board of the executive and judges should decide on this. Instead, the power was given solely to the executive in the form of the veto. Many also thought this would be useful to protect the executive, whom many worried might become beholden to an imperial legislature. Also, during the deliberations, the New Jersey Plan was introduced, although it was more of a protest to the excessive national character of the Virginia Plan, and was not seriously considered. The office of vice president was also included later in the deliberations, mainly to provide the president a successor if he was unable to complete his term, but also to provide presidential electors with an incentive to vote for at least one out-of-state candidate in addition to a favorite son from their own state or region. The early debate. Each state was allowed to cast a single vote either for or against a proposal during the debates in accordance with the majority opinion of the state's delegates. 83 Throughout the convention, delegates would regularly come and go, with only 30 to 40 being present on a typical day. Consequently, if a state's delegates were equally divided in their views on a given proposal, or if too few of the state's delegates were in attendance to establish a quorum for the delegation when votes were being cast on a particular proposal, that state's delegation had essentially no effect on the outcome of the vote on the proposal. Thus, for example, after 2 of New York's 3 delegates abandoned the convention in mid-July with no intention of returning, New York was left unable to vote on any further proposals at the convention, although Hamilton would continue to periodically attend and occasionally to speak during the debates. The first area of major dispute was the manner by which the lower house would be apportioned. A minority wanted it to be apportioned so that all states would have equal weight, though this was never seriously considered. Most wanted it apportioned in accordance with some mixture of property and population. Though there was discussion on how to calculate property for this purpose, the issue of property was later dropped because of its difficulty, and an assumption that property would closely correlate to population. Most accepted the desire among the slave states to count slaves as part of the population, although their servile status was raised as a major objection against this. The 3/5 compromise, assessing population by adding the number of free persons to 3/5 of all other persons, slaves, was agreed to without serious dispute. In 1783, when attempting to assess a national taxation system, the Confederation Congress had considered a 3/5 ratio, which did not achieve unanimity. This compromise resulted in a large coalition of states, including the small slave states of South Carolina and Georgia, backing the Virginia Plan and thus expanding the power of the primary coalition. That the lower house was to be elected directly by the voters was also accepted without major dispute. More contentious than the lower house was the question of the upper house. Few agreed with Madison that its members should be elected by the lower house. James Wilson suggested election by popular vote versus election by state legislature, but his proposal was shot down 10-1 by the delegates. Most delegates didn't question the intelligence of the voters, rather what concerned them was the slowness by which information spread in the late 18th century. At the time of the convention, they noted that local newspapers said little of current events, and what little they had was sketchy and dated. Local papers even said little about the meeting of the convention. Alexander Hamilton proposed extending the term in office for senators to life, considering earlier proposals of 4 and 7 years inefficient to enable the rich and well-born to have a distinct, permanent chair in the government, which could check the imprudence of democracy. Moreover, Hamilton proposed that senators not be elected directly by the general public, but by electors chosen for that purpose. Besides the problems of direct election, the new constitution was seen as such a radical break with the old system, by which delegates were elected to the Confederation Congress by state legislatures, that the convention agreed to retain this method of electing senators to make the constitutional change less radical. The more difficult problem was the issue of apportionment. The Connecticut delegation offered a compromise, whereby the number of representatives for each state in the lower house would be apportioned based on the relative size of the state's population, while the number of representatives in the upper house would be the same for all of the states, irrespective of size. The large states, fearing a diminution of their influence in the legislature under this plan, opposed this proposal. Unable to reach agreement, the delegates decided to leave this issue for further consideration later during the meeting. The delegates couldn't agree on whether the executive should be a single person, or a board of 3. Many wished to limit the power of the executive and thus supported the proposal to divide the executive power between 3 persons. The possible problems of this system, in addition to the knowledge that George Washington would probably be the first president, calmed the fears enough so that the proponents of a singular executive could accumulate a large coalition. This issue came up occasionally after the matter was settled, but was never again seriously doubted. Another issue concerned the election of the president. Few agreed with Madison that the executive should be elected by the legislature. There was widespread concern with direct election, because information diffused so slowly in the late 18th century, and because of concerns that people would only vote for candidates from their state or region. A vocal minority wanted the national executive to be chosen by the governors of the states. The issue was one of the last major issues to be resolved, and was done so in the Electoral College. At the time, before the formation of modern political parties, there was widespread concern that candidates would routinely fail to secure a majority of electors in the Electoral College. The method of resolving this problem therefore was a contested issue. Most thought that the House should then choose the president, since it most closely reflected the will of the people. This caused dissension among delegates from smaller states, who realized that this would put their states at a disadvantage. To resolve this dispute, the convention agreed that the House would elect the president if no candidate had an electoral college majority, but that each state delegation would vote as a bloc, rather than individually. As the convention was entering its second full month of deliberations, it was decided that further consideration of the prickly question of how to apportion representatives in the national legislature should be referred to a committee composed of one delegate from each of the 11 states that were present at that time at the convention. The members of this Grand Committee, as it has come to be known, included Elbridge Gerry, Oliver Ellsworth, Robert Yates, William Patterson, Gunning Bedford, Jr., George Mason, William Davey, John Rutledge, Abraham Baldwin, and Benjamin Franklin. In its report to the convention on July 5, the committee offered a compromise. The large states had opposed the Connecticut Compromise, because they felt it gave too much power to the smaller states. The Grand Committee's proposal added the requirement that revenue bills originate in the lower house and not be subject to modification by the upper house, although this origination clause would later be modified so that revenue bills could be amended in the upper house, or Senate. With this modification, the convention in a close vote adopted the compromise on July 16. Nationalist delegates remained bitterly opposed, however, until on July 23 they succeeded in further modifying the compromise to give members of the Senate individual voting power, rather than having votes taken by each state's representatives en bloc, as had occurred in Congress under the Articles of Confederation. This accomplished the nationalist goal of preventing state governments from having a direct say in Congress's choice to make national laws. The final document was thus a mixture of Madison's original national constitution and the desired federal constitution that many of the delegates sought. The first draft. The convention adjourned from July 26 to August 6 to await the report of the Committee of Detail, which was to produce a first draft of the Constitution. It was chaired by John Rutledge, with the other members including Edmund Randolph, Oliver Ellsworth, James Wilson, and Nathaniel Gorham. Though the committee did not record minutes of its proceedings, 3 key surviving documents offer clues to the committee's handiwork: an outline by Randolph with edits by Rutledge, extensive notes, and a second draft by Wilson, also with Rutledge's edits, and the committee's final report to the convention. From this evidence it is thought that the committee used the original Virginia plan, the decisions of the convention on modifications to that plan, and other sources, such as the Articles of Confederation, provisions of the state constitutions, and even Charles Pinckney's plan, to produce the first full draft, which author David O. Stewart has called a remarkable copy-and-paste job. Randolph adopted 2 rules in preparing his initial outline: that the Constitution should only include essential principles, avoiding minor provisions that would change over time, and that it should be stated in simple and precise language. Much of what was included in the committee's report consisted of numerous details that the convention had never discussed but which the committee correctly viewed as uncontroversial and unlikely to be challenged, and as such, much of the committee's proposal would ultimately be incorporated into the final version of the Constitution without debate. Examples of these details included the Speech and Debate Clause, which grants members of Congress immunity for comments made in their jobs, and the rules for organizing the House of Representatives and the Senate. However, Rutledge, himself a former state governor, was determined that while the new national government should be stronger than the Confederation government had been, the national government's power over the states should not be limitless, and at Rutledge's urging, the committee went beyond what the convention had proposed. As Stewart describes it, the committee hijacked and remade the Constitution, altering critical agreements the convention delegates had already made, enhancing the powers of the states at the expense of the national government, and adding several far-reaching provisions that the convention had never discussed. The first major change, insisted on by Rutledge, was meant to sharply curtail the essentially unlimited powers to legislate in all cases for the general interests of the Union that the convention only 2 weeks earlier had agreed to grant the Congress. Rutledge and Randolph worried that the broad powers implied in the language agreed on by the convention would have given the national government too much power at the expense of the states. In Randolph's outline, the committee replaced that language with a list of 18 specific enumerated powers, many adopted from the Articles of Confederation, that would strictly limit the Congress's authority to measures such as imposing taxes, making treaties, going to war, and establishing post offices. Rutledge, however, was not able to completely convince all of the members of the committee to accept the change. Over the course of a series of drafts, a catch-all provision, the necessary and proper clause, was eventually added, most likely by Wilson, a nationalist little concerned with the sovereignty of individual states, giving the Congress the broad power to make all laws that shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States, or in any department or officer thereof. Another revision of Wilson's draft also placed 8 specific limits on the states, such as barring them from independently entering into treaties and from printing their own money, providing a certain degree of balance to the limits on the national government intended by Rutledge's list of enumerated powers. In addition, Wilson's draft modified the language of the Supremacy Clause adopted by the Convention, to ensure that national law would take precedence over inconsistent state laws. These changes set the final balance between the national and state governments that would be entered into the final document, as the Convention never challenged this dual sovereignty between nation and state that had been fashioned by Rutledge and Wilson. Another set of radical changes introduced by the Committee of Detail proved far more contentious when the committee's report was presented to the Convention. On the day the Convention had agreed to appoint the committee, Southerner Charles Cotesworth Pinckney, of South Carolina, had warned of dire consequences should the committee fail to include protections for slavery in the southern states, or allow for taxing of southern agricultural exports. Pinckney and his fellow Southern delegates must have been delighted to see that the committee had included 3 provisions that explicitly restricted the Congress's authority in ways favorable to Southern interests. The proposed language would bar the Congress from ever interfering with the slave trade. It would also prohibit taxation of exports, and would require that any legislation concerning regulation of foreign commerce through tariffs or quotas, that is, any laws akin to England's Navigation Acts, pass only with 2/3 majorities of both houses of Congress. While much of the rest of the committee's report would be accepted without serious challenge on the convention floor, these last 3 proposals would provoke outrage from Northern delegates and slavery opponents. The final report of the committee, which became the first draft of the Constitution, was the first workable constitutional plan, as Madison's Virginia plan had simply been an outline of goals and a broad structure. Even after it issued this report, the committee continued to meet off and on until early September. Further modifications and concluding debate. Another month of discussion and relatively minor refinement followed, during which several attempts were made to alter the Rutledge draft, though few were successful. Some wanted to add property qualifications for people to hold office, while others wanted to prevent the national government from issuing paper money. Madison in particular wanted to push the Constitution back in the direction of his Virginia plan. One important change that did make it into the final version included the agreement between Northern and Southern delegates to empower Congress to end the slave trade starting in 1808. Southern and Northern delegates also agreed to strengthen the Fugitive Slave Clause in exchange for removing a requirement that 2/3 of Congress agree on navigation acts, regulations of commerce between states and foreign governments. The 2/3 requirement was favored by Southern delegates, who thought Congress might pass navigation acts that would be economically harmful to slaveholders. Once the convention had finished amending the first draft from the Committee of Detail, a new set of unresolved questions were sent to several different committees for resolution. The Committee of Detail was considering several questions related to habeas corpus, freedom of the press, and an executive council to advise the president. Two committees addressed questions related to the slave trade and the assumption of war debts. A new committee was created, the Committee on Postponed Parts, to address other questions that had been postponed. Its members, such as Madison, were delegates who had shown a greater desire for compromise and were chosen for this reason.
Please subscribe and thanks for watching.